Right, well, good morning, everybody. Welcome to the Palmers webinar. I'm delighted to welcome Samantha Randall this morning, who is our employment solicitor based in Basildon. Today we're going to be talking about the redundancy process. So just before I hand over to Samantha, we will have a live Q&A at the end of the presentation today. So if you have any questions as we go along that you raise, please use the Q&A tool on your Zoom toolbar. Post your questions. At the end, we'll try and answer as many of those live as we possibly can. So at this point to Samantha, and I will see you at the end for the Q&A session. So over to you.
Thank you, Jo, and good morning everyone, and thank you for joining us for this redundancy webinar this morning. So what we'll be doing this morning is taking you through the process of redundancies, and we'll touch on a bit of the furlough scheme as well, given that that's going to be relevant for a lot of employers at the moment. So the first question is, what is a redundancy? Now, a redundancy is used to describe a situation in which an employer decides to reduce the number of its employees, either within the business as a whole, at a particular site or unit, or the actual function or job role. Now, an employer might decide to make redundancies for various types of reasons, and these can include a recession or any other economic pressures. Obviously, the most relevant, today, is as a result of the coronavirus. There could be changes in the nature of services or products. Obviously, a lot of employers are adapting to working remotely at the moment. There could be internal reorganisation used to make efficient other roles or duties. And there could, of course, be technological developments that might result in changes to particular job functions. And lastly, obviously, relocation as well. Now, the law doesn't interfere with the employer's freedom to make business decisions, provided that a tribunal is satisfied that a redundancy is for a genuine reason. It won't look at the situation behind the facts of how the actual redundancy arose. So businesses have the freedom still to make their own decisions. So how does that impact when looking at unfair dismissal? So in order for a dismissal for redundancy to be fair, an employer needs to establish that the redundancy was the real reason for the dismissal occurring. Now, the tribunal must find that the employer acted reasonably in the circumstances in treating as the redundancy as the reason for dismissing that particular employee. So this in practice means that the company needs to have followed a fair procedure. And this is outlined in the case of Polkey, which basically sets out the criteria to say that employers need to follow a fair procedure when making decisions in terms of termination. Now, there are some cases in which confirmed that an employer will have acted reasonably, and therefore a dismissal would be unfair unless it has adopted the following processes. And they are that it warns and consults employees or their representatives about any proposed redundancies, that they adopt a fair basis for which to select redundancies. So an employer must identify from the appropriate pool in which redundancies may occur and select those potentially redundant employees against a proper criteria. And finally, another duty which an employer must consider as part of a redundancy process is considering whether there is suitable alternative employment within a company. So each employer must search for and make available any roles that particular affected employee could apply for within its company and also its wider organisation if there are group companies as well. So step one then is, before you embark on your redundancy process, is essentially to decide and establish whether there is a genuine redundancy situation that has occurred. Now, this can be for one of three reasons. So the firstly is whether there is a closure of the business for which the employee is employed. The second is if there is a closure of the particular place of business where the employee was employed to work. So if one particular branch of a company is deciding to close that particular premises. Or lastly, and which is the most common, is where there is a reduced requirement for the number of employees to carry out a particular role. So once you have decided which of the scenarios fits the situation, you can then move on to step 2. So this will be considering the pool of people that you would select for redundancy and the selection criteria that you will apply to that pool, and any alternative vacancies that exist within the company. So broken down, what that means is that firstly you would need to establish how many redundancies are being proposed. Now this is quite crucial when it comes to consultation. So if there are 20 or more redundancies that are being proposed within a 90-day period, then collective consultation obligations will arise. And this includes notifying the Secretary of State that there are going to be proposed redundancies of more than 20. If, however, there are fewer than 20 redundancies being proposed, then it's simply necessary just to follow a fair procedure in relation to each employee who is at risk. Now, the next step, as said, is to consider what the appropriate pool of employees that you will be selecting from, and to then establish the proposed set of objectives for that selection criteria as to how you will decide who will potentially be made redundant. An employer will also need to put together a list of all of the different vacancies that are existing within the group at the time, to see whether there are any ways in which redundancies can be avoided by simply transferring members of staff to different roles if they are already vacant in the company. Now, special consideration needs to be given to those employees who are pregnant, or maternity leave, adoption leave, or shared parental leave, as special rules apply to them on redundancies. So firstly, coming back to the issue of the selection pool. Now, there are no fixed rules about how a pool should be defined. However, some principles have emerged from case law over the years. So firstly, in deciding whether a redundancy selection was unfair, a tribunal must firstly decide whether the employer's choice of pool was in the range of reasonable responses. So here the question is how the pool should be defined is quite a primarily matter to the employer to determine, and provided the employer generally applies its mind to the pool as to how it's chosen to select those particular employees, then it's going to be quite difficult for an employee or a tribunal, in fact, to challenge that choice, albeit it's not impossible. So it needs to be shown that the employer has actually put their mind to, given how they will select that pool and why they have decided to include such people in that pool. So this might be a particular grouping of roles or a particular department. And a particular set of circumstances might give rise to a variety of different pools. And there is, again, no legal requirement that a pool should be limited to the employees doing the same or similar work. So as I said, you could have a department with various different roles within that, and they could all be included in a pool. So usually an employer will want to keep the pool for selection fairly narrow. But if you were an employee, then obviously you would potentially argue that the pool should be wider, as obviously this will lower your risk of being made redundant. Now, it has been held that to be it can be fair to place employees in a pool of one, and the fact that an employee can choose a redundancy pool, which is the same size of the number of redundancies being made, has been confirmed in previous case law. However, employers should always be cautious when doing so, as tribunals are likely to carefully scrutinise such decisions, just because obviously as soon as you are placed in the pool, you're pretty much automatically going to be made redundant if there is no one else and there is the same number of redundancies that are going to be made. So there are various different factors that are likely to be relevant when identifying a pool and how you're going to decide what that pool should be made up of. So One fault might be considering the type of work, whether that's ceasing or diminishing, the extent to which employees are doing similar work or even those at other locations, the extent to which employees' jobs are interchangeable as well. So you might have various different positions all in one pool just because their jobs are interchangeable. And again, it's about generally applying your mind to the composition of that pool to show that you've actually considered and thought about that. And in other cases, you may have well agreed to the pool and the makeup of that pool with a union or an employee representative. So there are unlikely to be any issues there if that is the case. So moving on then to the selection criteria. So once you have your pool, you need to consider whether the selection criteria that you're going to use to actually score those employees is reasonable. So in order to be reasonable, the selection criteria should, as far as possible, be objective and capable of independent verification. So this means that the criteria should be measurable rather than just based on the personal opinion of, for example, the manager that is conducting that scoring. So potentially fair selection criteria can include performance and ability, length of service, attendance, or disciplinary records. So it is legitimate for an employer to attach weighting to such criteria, reflecting their importance of what they believe different areas should be given, depending on the role and the position and how important that is to the company. So as long as you as an employer will be able to justify the weighting and why you have given such weighting and score to that particular area. Obviously, employers need to avoid any criteria which can be deemed as discriminatory. So any selection criteria that discriminates directly on the grounds of any protective characteristics. So this is things like sex, maternity or pregnancy, marital status, civil partnership, age, race, disability, sexual orientation, gender reassignment, or religion or belief, is likely to find that the redundancy is unfair. And this also includes grounds on fixed term or part-time status as well. If any of those selection criteria are applied, then the redundancy is potentially going to be deemed as an unfair dismissal. And in addition, there could be a potential finding of unlawful discrimination as well. So selection on purely subjective grounds is also likely to be unfair, given that the whole purpose is to try and make it as objective as possible to ensure that an employee is not selected by a manager due to any personal animosity or for any automatically unfair or discriminatory reason. So moving on to a couple of examples of the different selection criteria. So the most common one is probably last in, first out. So it's a common method used in redundancy selections. However, this can be quite a blunt instrument, and in recent decades it's fallen favour to a dominant criteria. It is more likely to be viewed as acceptable if it's used as part of a balanced set of criteria or in a tie-break situation where other factors are equal. But if you are solely to use this criteria alone, then it is likely to result in an unfair dismissal claim or even indirect discrimination on the grounds of age or sex. Obviously, in the various factors, if you're the last one in, the first one out, you know, whether it might be because of pregnancy or because, you know, you're younger and you haven't been in the company for as long. So using that ground solely on its own is likely to be quite risky. The next common ground for selection could be either performance and ability. So it's important that an employer chooses clearly defined criteria and a system of weighting that relates to any skills, knowledge required for its current and its future needs. So in assessing the performance of each employee, as an employer, you should refer to written records such as performance appraisals. It's going to be very difficult for an employee to challenge if you rely on performance appraisals, particularly where there's been agreed comments within those appraisals. So the main problems that can arise in relation to the assessment of performance, which is based on appraisals, is obviously if appraisals haven't been carried out regularly or for some time for all or some of the staff in that pool. And another issue might be if the appraisals have been carried out by different managers, who may not necessarily have the same approach. However, in some cases, some form of independent assessment of the appraisals ought to take place. So scoring should be undertaken by more than one individual if possible to minimise subjectivity. So usually we would say two managers should undertake the scoring process. And finally, another common area of selection is based on attendance records. So where an employer wants to refer to attendance records, obviously you should double check the accuracy of the information and the reasons for absences, and any consideration should be given whether there is a particular period of absence which should be discounted. So for example, if there is absence related to a pregnancy or a pregnancy related illness, maternity or any other family friendly leave rights, they should obviously be discounted. And if the employee's absence is connected with a disability, then selection for redundancy on a grounds of attendance may amount to disability discrimination on the basis that the employer should make a reasonable adjustment, just because those with a disability are more likely to have more time off work. So the next step as part of the process is then looking at the duty to look for alternative employment. So a dismissal is likely to be unfair if at the time of the dismissal, the employer didn't give any consideration to whether any suitable employment existed within its company at the time. So you should make sure that you undertake a sufficient and thorough search of any alternative employment that exists within the company at the time, and that search is documented to show that you've taken steps just in case you need to produce evidence at a later date if there should be a claim of unfair dismissal. Since the fairness of a redundancy dismissal is not only judged on the date in which the notice of termination is given, but actually when the employee's employment actually terminates as well. So that duty to look for alternative employment extends all the way up to their actual termination date. So you should also provide employees with sufficient information about any vacancies so they can then take an informed view as to whether a position is suitable for them, as to whether they want to apply for it or not. So linked to alternative employment is then trial periods. So if an employee does accept an offer of alternative employment, it might be subject to what's called a statutory trial period. So if you as an employer refuse to allow a trial period, any subsequent redundancy dismissal could be unfair, and it could be true if the employer in breach of contract refuses a trial period in which they may be contractually entitled to. So keeping on the subject of alternative employment, we'll then look at the suitability of any alternative employment and whether it is reasonable for an employee to refuse that. So if an employee unreasonably refuses an offer of suitable alternative employment, or if they unreasonably resign or give notice during the trial period, they will have been treated as being dismissed by their employer and they will lose their right to statutory redundancy. So looking at the actual suitability of an alternative position, so this is relevant particularly where the terms of the alternative employment offered are different from the employee's existing terms. So it again requires objective assessment of whether, having regard to the nature of the job offered. So the tribunal will take into account a number of different factors, such as the employee's skill, their aptitude and their experience, and whether they meet the requirements of the job that is on offer. They will then look at the terms of the alternative job. So for example, the status, the place of work, the tasks that are required as part of that role, the pay, the hours, or the responsibilities. And they will compare how the terms of the employment compare to their previous role. So it's not an entirely objective test as selection criteria is. And the question is whether the alternative employment is suitable for that particular employee. So there are a couple of further considerations when deciding whether a role is suitable. So the first, as we touched upon, is status. So if there is a drop in status, it is likely to make an offer unsuitable, even if the pay is maintained. Another consideration is the job of the content and the tasks that entails. So as I said, there will be a comparison between the old job and the new role offered, and whether the employee's offer of suitability matches with the employee's actual skill set. If it does not, either because the job fails to use the employee's skills or because it makes demands of the employer that they simply cannot meet, then the new role is unlikely to be suitable. Another factor in deciding whether an employment is suitable is the actual pay and the benefits that come with this. So whilst the fact that an employee's pay is preserved will not itself be sufficient to make an offer suitable, but a significant drop in earnings is likely to make a position unsuitable. So this because it impact their lifestyle, their career choices, that kind of thing. So where there is a significant drop in salary, then it's likely to make a role unsuitable. Another consideration is then the actual hours of work as well. So a tribunal will consider both the total number and the arrangement of working hours when considering whether an alternative role is suitable. So this could be changes in shift patterns, a loss of overtime, or the impact on an employee's outside commitments might be relevant as well. And again, lastly, the location is obviously a factor that employers will also consider. So the location of a job might be relevant, as obviously commuting isn't regarded as a joy for anyone. So when looking at how reasonable it is then to refuse a suitable alternative offer of employment, depends on, as I said, the subjective reasons that that particular employee has for rejecting it. So this will cover a number of factors in itself. So it could be that the circumstances in which the offer is made itself could be a reason for the employee to refuse a job if they are given insufficient time to consider as to whether they want that job or not, or whether they have any doubts about the employer's actual motive for making that offer. Another consideration is the duration of the job itself. Is it only going to be for a temporary period, or is it a permanent role? So obviously that's likely to impact an employee's decision. And again, it also relates to their personal circumstances as well. So it could be their health, their personal or family commitments, and other factors which we've already touched on, such as a loss of status, which could be interfere with their perception of that role. If there is a requirement to relocate, you know, whether someone is prepared to actually move their life to a different location may be a fair reason for refusing a role on reasonable grounds. and whether there's going to be an increased time and cost of travel to a new workplace. And another consideration might be the career choices as well. So if someone has a personal decision to pursue a particular career path, it might make it reasonable for them to refuse that offer, particularly if the new role is effectively a sidestep in their career. So the more suitable an offer, then the easier it is for an employer to show that the refusal was unreasonable. Now, as I said before, there are special rules relating to employees who are on maternity, adoption leave or shared parental leave. So where any of the potential redundant employees are under that category, so if they're on maternity leave, adoption leave or shared parental leave, then obviously employers need to be very careful not to discriminate, as the employee may have a priority right to any suitable alternative vacancies within the company. However, obviously employers need to take care to ensure that other employees are also treated fairly too. So once we have our pool, we have decided on our selection criteria and we have considered alternatives. At this point, obviously, we would need to notify the Secretary of State if there is going to be a collective redundancy. So, as I said, this only applies if you're making quite a large number of people redundant in a fairly short period of time. So, at least 30 days before the first dismissal takes place. In other words, the date in which the notice is to expire or employment is to end, where there is a proposal to dismiss between 20 and 99 employees within a 90-day period. And you must notify at least 45 days if there is a dismissal which takes effect, if you are dismissing 100 or more employees within a 90-day period. And this notification must be in writing. There is a set form that would need to be completed and provided to the employee's representative. And it's important to note that the employees cannot be given notice of a dismissal until this process has taken place. So moving on to the next step then, depending on whether the collective consultation applies, the next step is the first meeting that you have with the employees, in which you notify them that they are at risk. So what would happen is that you would normally meet with all of the employees who might be made redundant, and that would usually be done as a group. Obviously, in the circumstances, you may wish to do that by a video call or over a conference call, and explain the potential, the reasons for the potential redundancy. So what is the reason that the company is having to consider this? You should then explain how many jobs are at risk, and make sure that it's clear to all of the employees that this is only a possibility at this stage. Obviously, the company needs to consider ways of avoiding redundancies and ensure that they are explored. So this could be putting a restriction on recruitment, considering any alternatives roles within the company, if retraining is necessary, or offering voluntary redundancy or potentially short-time working or restricting overtime. So it's important that the company really puts its mind to consider all of the different ways to try and avoid a redundancy, and it's really as a very last resort. As part of that first meeting, obviously you can open it up to the employees and ask for suggestions as to ways that they can, redundancies can be avoided. You might well ask for volunteers to consider redundancy on a voluntary basis, and you would then explain the pool of people and what the proposed selection criteria will be. Employees obviously need to be informed that they have the right to take time off to seek alternative employment, so things like attending interviews, and it's important that you take a note of this first meeting. So once the meeting has happened, you should then follow this up in writing. This will confirm the information that's been given in the meeting and include a copy of the selection criteria or scoring guidelines if relevant and if you have them in place already. So going back to collective consultation, again, you might need to hold elections to elect representatives if you don't have anyone in place yet. And you'll need to consult with the appropriate representatives on ways to avoid or reducing dismissals and mitigating the consequences. And the consultation will usually cover the appropriate pool and selection and the selection criteria as well, as we've already discussed. So the next stage then is when you actually get on to the scoring of these employees. So you should score each potentially redundant employee using the selection criteria and scoring guidelines that you have supplied. And as I said, you should ensure at least 2 line managers conduct the scoring to help ensure that the scores are objective as possible. At this point, you would then write to your employees again with a second letter. And now this letter will invite those who have provisionally been selected for redundancy using your scoring and inviting them for a meeting to discuss their provisional selection. They have a right to bring a trade union or a colleague with them to the meeting, as this is the first formal consultation meeting that you'll be having. So the letter itself should be reasonably detailed, setting out the reasons for the redundancy again, and the provisional selecting of the employee for redundancy, and summarising the consultation on what's happened up to date. So at this point, you would have only had a group meeting, which you would have told that they would have been at risk. So you should make sure that it's clear that no final decision has been made at this stage and that a further meeting will be arranged if their selection for redundancy is confirmed. And obviously you need to allow the employee a reasonable opportunity to consider that information before the actual meeting takes place. So usually a couple of clear days before that first consultation meeting is actually held. So when you actually hold that first individual meeting, you would essentially consult with each employee individually about their scores and the proposal to select them for redundancy and the terms of what their redundancy will be. So it's important that you consider any comments from the employee, particularly in relation to their scores. So they may query why they have been scored what they have and for what reason. And you'll also discuss if there are any alternative roles within the company at the time. Again, you would need to take a detailed note of that meeting just to ensure that you have a clear paper trail throughout. Now, the next stage, once you've had that meeting, is to then follow that up. So if there are any suggestions that are made within that meeting about the ways in which redundancies could be avoided, or if there has been any representations about the scores that have been provided, then you should follow that up with the employee. If, as a result of that, the employee's scores change, then you will need to check if this will result in a change of the grouping and whether they would still be classed as provisionally selected. So if you have a particular threshold of a score, will that adjustment mean that they are no longer at risk and are no longer provisionally selected? If so, then you would again need to repeat the parts of the procedure with any employees that have been selected for redundancy as a result. So if this bumps another employee into that provisional selection. So at this point, you would then hold a second consultation meeting with the employee. So where the decision has already been made to make the employee redundant, you would invite them to a meeting to discuss that. Again, they will be allowed to be accompanied by a trade union representative or work colleague. And assuming that nothing has changed in the interim, then you would actually confirm that the employee has been selected for redundancy. You would then go through the redundancy package that is on offer to them and remind them of their right to take time off to seek alternative employment. And again, you would follow up by taking a detailed note of this meeting. Following that meeting, you would again write to the employer, but this time unfortunately confirming their termination on the grounds of redundancy. You would specify their termination date, so this might be with immediate effect if you are paying an employee in lieu of notice, or for a date in the future if they are working their notice period. You should explain the calculations of the redundancy payment and any other payments that are being made, such as notice pay and holiday pay. You would again confirm that the employee has the right to appeal the decision, and you should explain how to appeal and the relevant time limit for doing this. So you may already have policies in place regarding appeals and the correct procedure. So when it comes to the appeal itself, if an employee has appealed the decision, then you would need to, of course, invite them to a further meeting to hear their appeal. Now, if possible, the meeting should be held by someone senior to the person who held the previous meetings, ideally not the same person, just to ensure that that we avoid bias as much as possible. And again, because this is a formal meeting, they are allowed to be accompanied by a trade union representative or a work colleague. And again, following this meeting, you should write to the employee confirming the outcome of the appeal and that this is the final decision by the company. And that is effectively the end of the redundancy process. So how does this relate to the current circumstances with many employees on furlough still? So obviously the government brought in the coronavirus retention scheme, which has obviously been extended till the end of October. So whilst there's not really been any changes between now and the end of July, save for the introduction of flexible furlough, obviously the scheme is changing from next month onwards, in which the contributions are going to start accruing for employers. So from August, employers will have to contribute both the national insurance and pension contributions, and this basically accrues up. So from September, they would also have to contribute 10% of that employee's wage, and in October, finally, when the scheme ends, the employer's contribution will go up to 20%. So obviously the purpose of the scheme itself was to avoid the need for redundancies. However, it is generally accepted that businesses simply won't return to the levels that they were prior to the pandemic. And it's likely to take some time for this to happen. And therefore jobs are still going to be at risk in the interim, given that we now have a set date for where the furlough scheme ends, but obviously that doesn't mean the economy is going to bounce back straight away. So the idea of bringing back employees on a part-time basis was designed to gradually encourage the safe return to work, and thereby avoiding the cliff edge when the scheme eventually comes to an end in October. Obviously this isn't completely avoidable in itself. So how does this impact with redundancy if an employee is currently on furlough? So given the scheme is obviously intended to keep people in employment, and to proceed with redundancies during this time when the government are ultimately bearing the wage costs may well be frowned upon. There is, however, nothing in the current government guidelines which prevents employers from making redundancies during furlough for the long-term survival of the business. If employers do make redundancies during this time before the scheme actually ends, then they may well need to justify why you're doing it rather than keeping those employees on the scheme until it ends. And there is a risk, obviously, that an employment tribunal might well consider it to be unfair dismissal if, in the circumstances, they could have kept someone on furlough for longer at minimal additional cost. So the normal rules apply, obviously, in relation to informing and consulting with employees who are at risk of redundancy, and you should carry out a fair redundancy process. As existing employment rights are unaffected, employers obviously need to bear in mind a fair process to avoid any unfair dismissal claims with those with sufficient service. Employees will be entitled to their contractual and statutory rights in the usual way. Given that those are on furlough and not supposed to be carrying out any work, then you just need to think about how you're going to communicate with them and how any consultations might be conducted, given that most of these will potentially need to take place remotely, perhaps by a video call, a telephone conference, as well as putting things in writing as well. So how does this impact on actual redundancy payments during furlough? So the government guidance makes it very clear that you cannot use redundancy payments to claim reimbursement for the actual statutory redundancy pay. The position on notice pay, however, is silent, and there is therefore a bit of a division of opinion on the correct approach to use. So one view is that an employee's right to notice in accordance with their contract has to be paid at their normal rate of pay. If this is right, then if notice is given during furlough, then an employer would need to effectively top up the furlough pay so that the employee is paid for any weeks which represent their notice period. And this is similar to the position regarding holiday pay, in which an employee is entitled to their full pay for that period. Another analysis is, however, that by agreeing to be furloughed, the employee has actually agreed to a reduction in pay for the whole period that they are on furlough, and that this applies whether they are on notice or not. So there is potentially the argument to say that you can use the furlough scheme to effectively pay someone's notice pay. And then finally, the last division of opinion, which could potentially complicate the situation even further, is whether the length of the employee's notice in comparison to the statutory minimum notice, which is similar to the position regarding notice for those who are on long-term sick. This would mean that for someone who is on the statutory minimum notice, they would be entitled to be topped up to full pay for all of their notice period, whereas someone whose notice period is at least a week longer than the statutory minimum would only qualify for the furlough rate. In my view, the safest approach is probably to top up the pay to 100%, but it's worth noting that this might not well be a legal requirement, but it might avoid issues further down the line. And that brings an end to our redundancy webinar. So unless you have any questions, I'll hand over to Jo.
Thank you very much, Samantha. That was great. We have got a couple of questions come in. Length of service, and I think the question, I thought this was discriminatory due to age.
Yes, so touching back, if I would take you back to when I was explaining the first in, last out mechanism for selection. As I said, this is a very high risk area. If you're just using this as your only selection method, then it is likely to be unfair for age discrimination and potentially sex discrimination as well. If it is part of a varied selection process in which you're considering other areas and giving other weightings, then not so much. But if you're going solely on that reason, then definitely there's potentially discrimination.
Okay. And a question here from Simon. What if voluntary redundancy is not offered at the first consultation?
Employers don't need to offer voluntary redundancy. It's just something, if they want to offer it, that they can. It's not, as I said, it's voluntary, it's not compulsory. It might be if their employer to have a conversation on that basis.
Okay. And further question there, is it essential to meet all candidates at the start?
You don't have to do it all as a group. Obviously, if you can, then obviously that's preferred, because you're seeing everyone at the same time to notify that they are at risk. But if it can't be done as a group, then if it's by phone, then that's okay. As long as you're having that conversation and keeping those employees informed.
Okay. A question here from Gina. If you have some furloughed and some staff working, can the redundancy pool consist only of furloughed staff, or would this be deemed unfair? Interesting question.
Well, going back to the actual selection process, when many employers decided to place employees on furlough, they may not have necessarily gone through a formal selection process as to who they decided went on furlough leave or not. It's likely to have been very quickly made decisions. So unless you have gone through that formal selection process and deciding who you placed on furlough leave or not, and made sure that that is fair as possible, then it's probably recommended that you need to do a formal selection process with both those who are on furlough and those who are not, to make sure that it is fair and that you've considered and made sure that there's no sort of discriminatory potential reasons there.
Here from Simon. What if the scoring is done by one person then checked as reasonable by two others? And should the candidate be given the scoring card and those of others in their group with their name redacted?
Okay, so if essentially, as long as the scoring has been verified and has not been solely due to the scoring of one manager, then if that has been verified by two other managers and they are agreeing with that the scores that are given are correct, then that potentially would be fair. In terms of the actual scoring, obviously the employee themselves are entitled to their own scoring card to see what they have been scored. They wouldn't necessarily be entitled to see the scoring of their other colleagues though, just due to data protection. Obviously I note that you've mentioned if names and was redacted as well. However, there might still be some sensitivity around that, particularly if you might well be able to work out who the scoring was in relation to.
Okay. A further question here. Should you inform everyone in the business, even if they're not at risk?
No, you don't have to inform everyone. I mean, if you've already decided on the pool that you will be selecting from, then it is only the pool that you would be putting at risk. Obviously, there are going to be some people in that pool that eventually, might not well be made redundant. So unless you are going through a selection pool in which only the people that are being selected are then made redundant, obviously this has a bit more of a risk factor in terms of if you're only putting the people at risk given the actual number of the people that you're then going to make redundant. Obviously you need to have a good reason as to why you've applied your mind to just the pool consisting of those people, but obviously you're appreciating that if you're putting people at risk that might not be made redundant, then obviously that's going to unsettle the workforce potentially as well. So it's something to apply your mind to when deciding what is a fair pool to begin with, and in terms of notifying who's at risk.
Okay. Right, I'm conscious of time here. So we've got one last question we can get to. If the appeal is heard by the same panel as those initially doing the scoring, is that a reason for unfair dismissal?
So it really depends on the size of the business. If it's a particularly small business, then you're likely to have the same person hearing an appeal. In relation to the scoring itself, if it can be carried out by someone else that then doesn't make the decision, then obviously that's going to be preferable. But it really depends on the size of the business as to whether there are people available for to undertake the different roles, because you might have someone that is essentially going to be the backup to hear any appeals, and so they might be keeping that person on reserve for that reason. So it might well be the same person that's done the scoring then obviously confirms the decision, and potentially the appeal as well, as I said, depending on the size of the business as to whether there is anyone of a senior level available to hear that.
Okay. All right, well, that brings us to the end of our time. Thanks very much, Samantha, for your presentation today. We have recorded the webinar, so it will be made available later on today on demand on the Palmers website. We'll send an email to everybody who's attended today with a link to that recording. And of course, if you've got any further questions or need our help, then please don't hesitate to contact Samantha. Details are all available on the site. Thank you very much.
Thank you.